agree with that. I think there's some caveats. If it's a credibility finding, for example, it's binding on this court. If it's a factual finding, generally it's binding if supported by substantial evidence. But I want to maybe take one step back from that question and talk more generally about the standard of review for hearsay.
Let me ask a follow-up on that question then. So is it possible at least, and maybe on this record it's not the case, but if we have findings related to the 5 factors, in particular here trustworthiness, that 2 district court judges could come out differently on that question, presented with the same record, and that particular finding would be binding on us under a substantial evidence review standard?
I would agree that is theoretically possible. I don't think that is the issue here, because regardless of which standard of review we're talking about, whether it's abuse of discretion or correction of errors at law, the district court here committed a legal error when it declined to follow this court's controlling case law when it did the analysis. That's a per se abuse of discretion. Declining to follow a controlling case abuses whatever discretion the district court may have. Generally speaking, I don't have a big problem with the defendant's argument here that correction of errors at law probably is not the right standard for at least this hearsay question. Of course, it's been in front of this court a number of times. The court has had the opportunity to back away from the correction of errors at law standard from Ross and Hallam in those cases. The court's declined to do so. But in all candor, I've made a version of the argument regarding the standard of review that you hear from the defense today, because it is anomalous that we have singled out hearsay as this one very special category of evidentiary ruling that is subject to a different standard. It's sort of at odds with general principles of appellate practice and standard of review. It's to some degree at odds with the federal case law. They use the vocabulary a little bit differently. They would say that the question on admission is probably reviewed de novo as a legal question as to what constitutes hearsay. Does it satisfy Rule 801 or not? But then the actual admission based on factors, something like excited utterance, is the person, the declarant, excited when they made the statement. That probably is reviewed for an abuse of discretion because it turns on a fact finding. It turns on a credibility finding about whether the district court has believed a particular witness. In that circumstance, I think abuse of discretion review is appropriate, but that doesn't determine our outcome here. In fact, what we have is this district court judge found the state's witnesses credible. That's the word the district court used. It said that Tamara Bibbins and Katie Strube were credible witnesses. So if we're going to look at the standard review and who it favors, even under an abuse of discretion, it favors the state. The district court credited the testimony of those 2 experts. The problem with the district court's analysis really isn't in that credibility or fact-finding realm. It's an application of controlling legal precedent from this court.
Let me ask you this. There's kind of a procedural oddity here I want you to help me with, and I think you probably anticipate it. I mean, the court didn't slam the door on the admissibility quite, at least looking at the language, right? The court says, well, I'm not letting it in on this record and, at this time and, kind of hedge words. And then, if I understand the record correctly, and I invite correction of me, you didn't really ask for a definitive ruling on admission. You wanted for the 4 factors of Rojas below, and necessity, I think, was going to be deferred. So I'm not 100% sure you have a definitive ruling from the district court. Now, tell me, A, I'm wrong, or B, it doesn't matter, but address that kind of procedural oddity, please.
So to A and B, I actually disagree with the court's conclusion, and I think it doesn't matter here. The reason I disagree is because there is a definitive ruling on 2 of the 5 prongs. This isn't a disjunctive test about factors where we consider everything and sort of mash it together and see what the result is. It's more like elements. The state has to show all 5 of the Rojas factors. So when the district court disagreed with 2 of them, that's trustworthiness and the interest of justice, that was necessarily exclusion of the evidence.
Didn't the court, I'm sorry to interrupt you, but didn't the court say, well, but at this time, and I want to hear more from, kind of more testimony. Now maybe that was an odd remedy in light of the procedural posture. You made that argument, and I understand that argument. But I think I'm just a little troubled by the fact that there's kind of some procedural leakage in the record.
Sure. For every example where the district court uses sort of fluffy or non-specific language, like Your Honor's question suggests, there is specific language. I'm looking at the last sentence of the first paragraph, page 142 in the appendix. It reads, and this is a quote, "The court excluded the CPC interview." I think that's about as specific as you can get. It is a finding that at least on those two prongs, the interest of justice and the trustworthiness, the court has found the evidence is not admissible. The necessity prong is sort of left open-ended for trial. We know there's maybe 3 different or 4 different circumstances that could happen. The victim gets on the stand, says what she said during deposition, which is, "I don't remember." She could say what she said in the letter that was put together by her grandmother and then witnessed by the grandmother to keep it in the family, which is kind of a recantation, maybe not quite. The victim could get on the stand, give some version of what she told the CPC interviewer and not give as much detail, or the victim could give all of the detail that she gave the CPC interviewer. I think the most likely is the first 3 because that's what we see in sworn deposition testimony, and then we see it in the letter. Is it possible in some theoretical world the victim will get on the stand and say in the same amount of detail what she told the forensic interviewer? Yes, there's an element of unpredictability to trying every child sex abuse case. I think it's very unlikely here. There's no reasonable probability that will happen. But I think that's what the county attorney was suggesting when he said that the court doesn't have to decide this necessity piece right now, but the court does need to decide the trustworthiness and the interests of justice. To the second piece about whether it matters that there's a little bit of irregularity here, it doesn't. This is an interlocutory appeal. This court has significant flexibility in what kind of remand, if any, it crafts. The reason the state here filed the 5104A motion is because a motion in limine was not the right way to resolve this question. I think everyone agrees with that. So the state filed the 104A motion asking for a ruling on 4 out of the 5 factors, the ones that could be proven before trial. The district court suggested...
To the extent that it seems like the district court was leaving the record open, and maybe your position is it's only to rule on necessity at some point, but to the extent that we think it was leaving the record or making an opportunity for the state to make further record on all of the factors, would it be appropriate to direct that the evidence be admitted versus just directing what the proper analysis would be at some future date if the state wanted to make another 104A motion?
Yeah, I think there are options in how you craft the remand. The court could direct a finding on the 2 factors that we're talking about today. The court could also say this case is remanded to be decided in light of the controlling factors set forth in State versus Rojas. Either of those are options. To the question about whether or not the district court did leave the record open, it's a little hard to figure out from the order. I do think the court intended to leave the record open on necessity, but it doesn't make sense to have left it open on the other 2 prongs because all the evidence that's going to exist for those 2 prongs was admitted at the 104A hearing. In fact, I would say the county attorney really went above and beyond. They called a second expert witness here. That's Ms. Strube from Waterloo, who's a supervisor there, to talk about the general expert principles and the background that goes into the forensic interview. The best evidence to decide whether the CPC tape complied with Rojas is the CPC tape. That's obviously in the record here. Then we have the testimony from Ms. Bibbins talking about why she asked the questions she asked. And we have the testimony from Ms. Strube about why those questions were appropriate and complied with the NCAC guidelines. There is no other evidence.
Here's the thing. I mean, I tend to agree with you that if Rojas stands, is still good law, that you're probably right. But I mean, is it the state's position that, let's say hypothetically the Polk County attorney could just have a forensic interviewer on staff, and whenever there is a reported crime, the forensic interview could interview the complaining witness, and then you just kind of put that in a non-suggestive way, and then you just kind of put that video kind of in the can, and then if the witness doesn't remember, you just bring it out at trial? Is that the state's position, basically?
First, I think it's very important to remember these forensic interviewers do not work for and are not part of law enforcement. They are not employed by the state. They are not employed by the county attorney.
All right, so let's solve that problem. All right, we get past that. Assuming we have someone that's contracted, not employed by the county attorney. All right, we get past that. Even so.
If a forensic interview is conducted pursuant to the NCAC guidelines, that's what they're talking about in Rojas with the open-ended, non-suggestive questions. If the interview is appropriately conducted and the state can satisfy the 5 prongs of Rojas, then yes, the CPC interview should come in. It's not going to be every case. Sometimes there is going to be a victim that can get on the stand and offer with the same degree of detail what they told the forensic interviewer. But my experience, I think that of other prosecutors who try these cases, is that would be the unusual case. The victims in these cases face extraordinary pressure to either change their story or to recant what we hear.
I don't dispute any of that. This doesn't sound like what I learned in law school about the residual hearsay exception, just as a general feel. I mean, it doesn't feel like what I was learning about. And maybe that's, when you say that everybody below was on a confrontation type analysis, maybe I am too. So are there other states that have precedents like Rojas?
Yes. In fact, my understanding is the vast majority of states have case law similar, if not identical, to how this state approaches it. Of course, we have a statute that also codifies it for children under 14. I'd like to speak just a moment.
I don't mind the small child example. 14, which we have here, is kind of getting to the borderline. 18, 20, that's what I'm concerned about.
I'd like to speak just a little bit to your gut reaction, which I think the hesitation is maybe that if we had an adult that had given a forensic interview, it wouldn't make as much sense. The reality is that children are different, and that's for the reasons I was speaking about. An adult doesn't face the same kind of pressure, especially in an intrafamilial case. Here we have the victim's grandma saying, you shouldn't have told anybody what happened. You should have kept this in the family. And, Your Honors, I can tell you that's not unusual in this case. It's not even the first time I've heard that particular formulation of please keep quiet. These victims are under tremendous pressure. We expect them as a child to come into the courtroom, often holding a stuffed animal, to sit on the stand and tell a room full of adult strangers about what is probably the most traumatic and horrific experience of their life. It is no surprise that when these victims get to trial, it is difficult for them to tell the same things that they told the forensic interviewer. The forensic interviewer's circumstance is dramatically different.
On that point, and maybe this is collateral to the main issue on appeal, to me that doesn't seem much different than a variety of cases where witnesses are pressured to recant or do not participate with the police and provide statements. And that applies with adults in serious crimes or violent crime contexts. It applies in domestic abuse situations. And it seems like all of the things you're identifying that make this trustworthy, reliable, and admissible applies in a variety of contexts outside child sex abuse cases. And that is concerning to me. I share Justice Mansfield's concern with that.
If I may respond.
Go ahead and answer the question.
Children are, in fact, different. Some of the pressures may exist with other types of victims or witnesses, domestic violence, for example. But it's dramatically different when the person that is providing you care at home is the person who's saying that you should recant or not tell your story. Children are so different in this context that the legal rules should be different. That's what this court has recognized time and time again. That is the holding of Rojas, and no one in this room today, based on the briefing, is asking this court to depart from that holding. I'd ask the court to enforce Rojas and reverse.
Thank you very much. Ms. Wilson?
May it please the court. Nobody is asking this court to overturn Rojas. However, I think it might be helpful to give the bar and lower courts some guidance when it comes to the admission of these CPC interviews. Rojas is not the be-all and end-all of the trustworthiness equation. Yes, it is how we look at the trustworthiness of the particular forensic interview that's been recorded. That's true. But we cannot forget the other factors that go into the trustworthiness analysis, as have been stated in Idaho versus Wright, in the State Sanders case, and by this court in Weaver and Paredes. And that is, you're also looking at whether the statements made by the declarant are consistent with somebody of their age, whether they are spontaneous or in a recorded interview such as this one, which actually undercuts the trustworthiness and reliability of the statement, whether the person was under oath. Or
Can you
subject-
reset the light, please?
and whether the declarant reaffirmed or recanted the statement. Here, we primarily are talking about Rojas. And the district court did actually point out a number of instances in the interview that it found troubling. And granted, I have dissected the interview ad nauseum in my brief. I want to hit 3 or 4 basic points that underscores the difficulties here. Ms. Bibbins asks where the declarant where the defendant would touch her. And she says at about 13:14:00, the surrounding skin of, I forget the term. Now, earlier she had mentioned that she had been touched on the breast and genitals. But she was having a hard time thinking about where she had been touched, how she was going to explain that. Ms. Bibbins then comes back to, you mentioned genital area. That brings the thought back into the declarant's head. Ms. Bibbins does ask the question whether something went inside her body, where the declarant had not mentioned that previously. This is probably the most troubling aspect to me. The declarant talks about how the defendant would come in and try to move her clothes to touch her. Ms. Bibbins asks, what would your dad say when this happened? The declarant never mentioned the defendant saying anything to her. And then the declarant gives a statement that illustrates the problem with the questioning. Initially, she says she told him to stop. But then she says, I don't know if this was my fear talking or what, but I feel like he told me not to tell anybody because of my fear. I don't know if it was an illusion because of my fear and the fear inside me, or if it really happened. This is the problem with leading and suggestive questioning, even with a 14-year-old.
I'll have to say, I watched the video too, like I'm sure you did, and I don't share the district court's concerns about the interview. The SV struck me came across to me personally as credible, but more importantly, isn't this an area where maybe it's an abuse of discretion type thing, like Justice McDonald was suggesting? Don't we give some deference to the district court here when we're sort of evaluating the trustworthiness of an interview?
Trustworthiness is inherently a discretionary area for the court. It's kind of akin to a motion for new trial, where the judge who heard the witnesses, heard the testimony, gets to determine the credibility, and this court is less likely to interfere with the grant of a new trial in that situation than with the denial. The argument with respect to the standard of review gets to that point. Prior to Ross, this court had applied an abuse of discretion standard to hearsay, just like it did for any other sort of evidentiary question. But then in Ross, this court said, we're going to use a correction of errors at law standard because the admission of inadmissible hearsay is inherently prejudicial to the non-offering party. Well, that makes sense. If it's inadmissible hearsay, then a correction of errors at law standard makes sense. But that was for the admission. It spoke nothing to the exclusion of evidence. And if you look at the federal rule, which is a mirror image, or at least it was, of the state rule, you see the purpose of that rule is very limited. The residual hearsay exception is only supposed to be used sparingly in exceptional circumstances. The first part of the rule talks about, or at least it did federally, about equivalent guarantees of trustworthiness, just as with other hearsay exceptions in Rule 803 and 804. So what you would have is a near-miss analysis. If it almost made the medical diagnosis and treatment exception, then we were more likely to find applicable the residual hearsay exception. And the courts, for that reason, have tended to use, in the federal system, an abuse of discretion standard. And it is very deferential to the district courts on their fact-finding, and it will only reverse if there is clear prejudicial error.
Your position is we should defer to the district court's determination that this didn't meet the trustworthiness standard, notwithstanding what my personal views might be. Is that
yes,
what you're saying?
because there is some evidence in the record to support it. And if there's some evidence in the record to support it, we should be giving deference to the district court. Of course.
What about the other factors where it seems like the district court was applying the wrong standards? I mean, you're not suggesting that we give deference to the application of the wrong legal standard as articulated in Rojas.
No, absolutely not. If it is a question of the application of a legal standard, that, as with the motion for new trial, is correction of errors at law. However, if you look at the ruling, the court referred to Rojas. The court referred to Neitzel. The court referred to the various requirements of 5.807. The court knew what the appropriate standards were. The reason the state is objecting is because they disagree with the factual analysis supporting the end result. Of course, this court doesn't even have to get there because the application for discretionary review was improvidently granted. And here we get into whether or not there was a definitive ruling. A motion in limine ruling is not definitive. Obviously, you have to get to trial and see how evidence pans out and if objections were made. The state's response to that is, oh, it's not just a motion in limine ruling, it's a ruling under 5.104 for the admissibility of evidence. Well, that doesn't help the state either. Under Cone, under Weaver, both of those cases say if one of those 5 factors under 5.807 is missing, the evidence is not admissible. There can be no ruling on the admissibility. The court, knowing that there was no showing of necessity at that point, could not say that the videotape must be admitted.
I mean, I'm somewhat sympathetic to the state's concern. I mean, we granted discretionary review, so in essence, it kind of doesn't matter how final whatever it is we're reviewing, does it? And what they're concerned about is they don't want a jeopardy to attach, and then the determination is effectively unreviewable if it goes against them at trial, right?
I understand the state's concerns, but it is not a final ruling. And because it is not a final ruling, what essentially this court would be doing is issuing an advisory opinion. If X, Y, and Z, then it's admitted. If not X, Y, and Z, then it's excluded. And it all depends on how the evidence pans out at trial. Because this court...
Why couldn't we look at this record in the video and then reverse the district court's ruling on certain elements and leave it open on necessity? That depends on the victim's testimony.
Well, here's part of the problem with that, in my opinion. The issues that the court had a problem with was trustworthiness and the interests of justice. Oddly enough, it did not find a problem with materiality and notice. Nobody's disputing notice in this case. I would suggest that any finding regarding materiality and the interests of justice are inherently based on the trustworthiness of the video. And the trustworthiness, again, deference should be given to the district court's findings on that component. And if the video is not trustworthy, then it's not probative, then it's not relevant, then it's not admissible. If this court did, in fact, improvidently grant the application for discretionary review, then I would suggest this court lacks subject matter jurisdiction to rule upon the merits. And that is because this court is given jurisdiction over appellate cases. under the Iowa Constitution. The only way to invoke this court's appellate jurisdiction is to properly perfect an appeal, which was not done in this case. In addition, the state failed to preserve error for appeal inasmuch as it asks for a ruling on admissibility. This court, error was preserved on the other 4 factors, but for the reasons I have stated and the discretion given to the district court, I would not reverse on that ground. Again, the CPC interview questions, I pointed out ad nauseum in the brief where the issues were. Because the questioning could not lead to a trustworthy result, because we're talking about a 14-year-old who has taken sexual education classes, who reported this after seeing a video discussing rape in her school, and therefore is using terminology that she would know as a 14-year-old and not as a 5-year-old, because she was not under oath, not subject to cross-examination, has recanted her statements. We would ask that this court, if it is not going to dismiss the appeal, then affirm the decision of the district court.
I want to make sure I understand correctly. You said something about you believe, and correct me if I'm wrong, that the state failed to preserve error on the admissibility aspect because of the necessity prong?
Right. Below, it did not request a finding on necessity, and if you don't have every one of those elements proved under 807, it cannot be admissible.
Isn't that premature, though? Because typically my experience is in a sex abuse case, those 4 are talked about, and the state just kind of holds that video behind their back. And then if things unfold that they feel it's necessary, they then ask, and then they can prove, now I'm telling you why it's necessary. Isn't it premature for the state? We're discretionary review. The case has not unfolded, so how can they show necessity if they themselves aren't sure? Maybe she'll testify to everything and they don't even need it.
That's possible. We won't know until trial, which is
But why do you say that the state has waived that?
Because in any other evidentiary context, you need to get a final ruling from the court on every component of whatever ruling you're seeking to appeal.
Not on discretionary review. How could somebody have made a motion for a new trial, for example, if it's not over yet? I mean, in a discretionary review that you've interrupted a trial, don't you think that's different?
Not necessarily. Had the district court made a finding on necessity, then the state could appeal that.
But on this record, doesn't that, to some extent, put the state at risk? I mean, as I see that playing out, to me that sounds like you're saying, well, right, now there's a potential Turachek violation, and you should have known that this witness wasn't going to say X, Y, and Z because you have a letter indicating she's recanted. I mean, I don't know. That seems like the state's in a tough position if that's the way you want to go with it.
It is, by operation of law and double jeopardy, potentially. If the defendant's acquitted at trial, they have his statement, supposedly, to a third party. We don't know what the victim, the declarant, is going to do. We don't know which version of her is going to show up at trial. If she shows up and gives the CPC interview statement during her testimony, there is no harm. And unfortunately, I sort of agree. This is all premature. We're trying to have sort of a trial before we get to the trial. I would, again, ask for either dismissal of the appeal or affirm the district court.
Thank you, Ms. Wilson. Mr. Bullard, do you have any rebuttal?
Yes, Your Honor. If the defendant is right about error preservation in this case, then every ruling on the Rojas question for a CPC interview is unreviewable if it is decided adversely to the state. If the state is required to obtain some kind of pretrial ruling on necessity in order to invoke this court's jurisdiction, the state will never be able to do so. For the arguments the defense has made today, that we don't know exactly what the victim will say at trial. We have a good educated guess here. We know she's likely to say what she said in deposition or what she wrote in the letter. But I'm not going to stand here and tell you we're 100% sure. And I think anyone who says they're 100% sure about what the testimony will be in a child sex abuse case is lying to themselves.
Oh, so it sounds like it's a bit of a contingent ruling. I mean, you're right. The HM is called as a witness. Could be she's remembers and fair detail and is reasonably lucid, and there's no necessity. Possibly, or the other is that no, she's kind of memory blocked and not very coherent. But of course, at this stage, we truly don't know. Doesn't that cause you kind of we're giving it was characterized as advisory opinion or a contingent opinion or opinion that isn't quite served up?
No, Your Honor. This court doesn't have to decide necessity in this appeal. There are at least two prongs on which the district court either abused its discretion palpably or erred at law. That's trustworthiness and the interests of justice. This court could hold off and say nothing about necessity, leave that for the district court to decide on remand. But either way, the trustworthiness and interests of justice prongs were so poorly decided that they must be reversed. And I want to talk briefly about that standard of review issue because it is floating in the background here. There are some abuses of discretion or exercises of discretion that are so palpably wrong that they must be reversed by an appellate court. An abuse of discretion isn't free license to just rubber stamp every evidentiary rule of the district court. If it was, the appellee would never lose an evidentiary issue, and of course that's not the case. There are some rulings that are so wrong under any standard of review that they must be reversed. And I want to talk about that interview here, and I hope the court has watched it. I understand not everyone might view it the same way I do, but that is powerful video. You see on the tape a scared teenager who's palpably nervous. You can see her fidgeting. She's uncomfortable. She doesn't want to be talking about these things. She's reluctant to use the word penis. She is so nervous about it that she writes it down rather than say it out loud, and that's in a controlled, comfortable situation. This is...
Can I want to make sure I get a chance to ask you about sort of the limits of what the state is asking for, if this is okay. The statute essentially says sexual abuse case and a statutory child, that is a kid under the age of 14. The state's position is what? Is it still limited to sexual abuse, but it can be anyone under a minor, anyone under the age of 18? Is that where you would draw the line?
It's not rigidly drawn. In fact, what we see the Court of Appeals has done, and this is consistent with case law in other states, is they've applied it to adults in some circumstances. They've applied it to non-sex abuse cases in some circumstances. It's easy to envision a scenario where the evidence is so trustworthy, regardless of the type of case or the declarant's age or particular status, that the evidence should be admitted under the residual hearsay rule. The better question, I think, is what does Rojas talk about? And Rojas acknowledges that there is a statute out there, but says the statute does not change the analysis under what was then Rule 803.24. Of course,
Rojas talks about a child, which could mean either a minor or a minor under the age of 14. Here we have someone who was 14. Watching the interview, again, for what it's worth, to me she comes across as pretty mature for a 14-year-old, and at the same time, credible. If Rojas talks about child, shouldn't the Rojas holding be limited at least to someone under the age of 18?
I have a two-part answer to that. First, that issue was not argued by the defense or really anyone in this case, so I think the court can comfortably set that aside. If we're concerned about what will be interpreted as the outer bounds of Rojas in the future, I think we can wait for a case to say that. One line you could draw is that it is under 18. If it were meant to be 14, the court in Rojas would not have said that the statute didn't change the analysis. The court would have said, no, that we have a brand new limit of 14 and it's been codified by the legislature. This court did not say that in Rojas. Instead, the court provided a framework that the district court in this case did not follow. regardless of whether we're talking about an abuse of discretion or an error at law, the district court's ruling must be reversed, and this court should remand.
Thank you, Mr. Bullard. At this point, the case of State versus Veverka is now submitted. You may recess court till this afternoon.
Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now adjourned.